Erice.
Thank you, Madam Chair. I would just like to manifest some of my observations on the first allegation in the MASA complaint. It's about the BBM parametric formula. While the allegation is grounded upon a paper proposing the adoption of BBM parametric formula, the statement shows that the same is created by DPWH. There is no allegation or statement showing any administrative order, memo, executive order, or any directive executed by the President himself. Secondly, even the statements on alleged kickbacks, Madam Chair, actually, the complaint pertains solely on alleged kickbacks involving DPWH officials and certain legislators and does not show any participation, knowledge, or consent on the part of the President. That's just my observation on the first allegation, Madam Chair.
The Honorable Erice.
Madam Chair, good morning. Matapos kong masusing suriin ang impeachment complaint na inihain nila Lisa Largosa Masa et al. Laban kay Respondent President Ferdinand Marcos Jr., malinaw sa akin na ang reklamo ay sufficient in substance. Batay sa pamantayan ng prima facie sufficiency. Linawin natin, hindi pa natin hahatulan ang Pangulo. Ang tanong lamang ngayon ay ito, kung mapapatunayang totoo ba ang aligasyon, may nagawang impeachable offense ba ang Pangulo? Ang sagot, oo. Ang reklamo ay hindi puro opinyon o konklusyon. May malinaw, tiyak at verifikableng mga katotohanan. Isang malinaw na halimbawa, ang malubhang kapabayaan ng Pangulo sa pagpayag na salaulain ang pambansang budget ng kanyang mga kaalyado. Daan-daang bilyong piso ayon mismo sa reklamo. Pinayagan ang insertions, diversions at manipulasyon. At sa kabila nito, nilagdaan at ipinatupad ang paglalabas ng mga pondong ito. Ayon sa reklamo, pinahintulutan at nilaglaan ng Pangulo ang paglalabas ng bilyong pisong unprogrammed appropriations, mga pondong walang tiyak na pinanggagalingan na ginamit umano sa ghost projects, substandard infrastructure projects, at maanumalyang flood control. Hindi ito simpleng pagkukulang. Ito ay systematic acts na tuwirang pumapasok sa betrayal of public trust. Ang reklamo rin ay malinaw na nagsasaad na pinayagan ng Pangulo ang paggamit at pagdivert ng pondo mula sa PhilHealth, PDIC, at Foreign Assisted Projects appropriations na nagdulot ng malalaking pagkaantala sa mga flagship projects ng ating bansa. Metro Manila Subway, PNR Elevated Rail at iba pa. Ang epekto nito, bilyong-bilyong pisong nawala dahil sa commitment fees, penalties at price escalation. Ito ay tunay na perang nawala, tunay na oportunidad na nasayang at tunay na pasaning ipinapataw sa mamamayang Pilipino. Ang reklamo ay malinaw na sumasagot sa mga batayang tanong. Sino ang gumawa? Ang Pangulo. Ano ang ginawa? Pinayagan at nilagdaan ng budget, manipulation at anomalous releases. Kailan? 2023, 2024 at 2025 GAA. Paano? Sa pag-aproba ng releases at kabiguang pigilan ang diversion ng pondo. Higit sa lahat, may direktang ugnayan ang mga gawain ito sa impeachable offense na betrayal of public trust. Ang mga aligasyon ay grabe. Tinatamaan ang public interest, sinisira ang constitutional order at winawasak ang tiwala ng mamamayan sa pamahalaan. Kung mapapatunayang totoo ang mga ito, may nagawang impeachable offense ang Pangulo. Iyan lang ang dapat nating pagpasyahan sa yugtong ito. Dapat bigyan ng pagkakataon ang mga nagrereklamo na magharap ng mga ebidensya, magsumite ng mga sworn statements at mapatunayan ang kanilang mga aligasyon. Kasabay nito, dapat ding bigyan ng pagkakataon ng Pangulo na ipagtanggol niya ang kanyang sarili. Ito ay hindi pag-uusig. Ito ay due process. Ito ay hustisya para sa nagrereklamo, para sa Pangulo, at higit sa lahat, para sa mamamayang Pilipino na may karapatang malaman, pinabayaan ba? May ginawa bang kasalanan? Pinagnakawan ba tayo? Kapag pinatay ang investigasyon, kung pipigilan ng komiting ito ang pag-usad ng investigasyon, ang magiging imahe ng Kamara ay may pinagtatakpan. Lalo na't maraming mambabatas ang di umano'y nakinabang. Maraming distrito ang biglang nagkaroon ng mga bilyong-bilyong alokasyon. At marami sa mga ito ay napunta sa mga flood control projects. Kung pipigilan natin ito, baka tayo mismo ay husgahan ng bayan bilang kasabwat sa pagtatakip sa katotohanan. Lalo pang magpapabagsak sa tiwala sa gobyerno, magpapahinya ng ekonomiya, magpapalayas ng investors, magpapawala ng trabaho at magpapalalim ng kahirapan. At sa susunod na tagulan, sa bawat baha, sa bawat dilubyo, sa bawat buhay na malalagas, tayo ang sisingilin ng mamamayan. Madam Chair, hindi natin dapat katakutan ang katotohanan. Ang dapat natin katakutan ay ang pagtatakip dito. Payagan nating umusad ang investigasyon, hindi para sa Pangulo, hindi para sa atin, kundi para ipagtanggol ang konstitusyon ng Republika. Maraming salamat po.
Madam Chair. Thank you, Honorable Erice. Before we proceed, please let the Chair read the 3 specific grounds for impeachment. First, under the first act of betrayal of public trust, institutionalizing systemic corruption through the BBM parametric formula of allocables.
She had to clarify.
Second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriations. And third act of betrayal of public trust, direct personal involvement in budgetary insertions and kickback schemes. For uniformity, since we deliberate on the sufficiency in substance, with respect to the De Jesus complaint per ground, we will be following the same system. So we are reminding the members to please confine the manifestation on the first ground first, and that is institutionalizing systemic corruption through the BBM parametric formula of allocables. That is for the guidance of the members. The Honorable Zamora.
Pwede ka nang...
Madam Chair, if I may make my manifestation as regards the entire complaint. Yesterday, it was made clear that for an impeachment complaint to be declared sufficient in substance, the recital of facts should constitute the impeachable offense charged. It is clear that we need to show the ultimate facts or the overt acts of the President in relation to the various schemes he allegedly perpetrated. The second complaint shows 3 different schemes. In brief, they are institutionalizing systemic corruption through the BBM parametric formula, abuse of discretionary power as regards unprogrammed appropriations, and direct personal involvement in kickbacks. These 3, in fact, are interconnected. It is all about the flood control scheme. I don't want to belabor the point, Madam Chair. It is clear from the complaint that the President did not do any overt act that will show that he directed these 3 schemes. In the first place, it was not the President who created the BBM parametric formula of the DPWH. Having an imperfect policy direction is not an impeachable offense. Second, that the Supreme Court struck down the provision relating to PhilHealth funds does not make the President primarily liable for such. The connection to corruption is highly speculative. Finally, that the President allegedly has a direct personal involvement is not clear from the allegations or borne out from the records. We should not tolerate the use of hearsay allegations, videos that are not attested to, or fake news. The Honorable De Lima yesterday repeatedly said that there should be a nexus between the specific acts and the impeachable offense charged, and I fully agree. Accusations are not factual allegations. A lot of what is written are mere speculations or conjectures, arising from hearsay and worse, even double hearsay testimonies, just to connect the president to the charges. To say that the office of the president has become the command center of a criminal enterprise is not only unfounded, but is also a mere dramatic rhetoric. Thank you, Madam Chair.
Thank you. Next, we recognize the Honorable Garbin.
Thank you, Madam Chair.
Madam Chair, may I also be recognized later on?
Honorable Garbin, then Honorable Gonzalez, then Honorable Abante, one after the other. Thank you.
Madam Chair, also, this representation, I've been raising my hands early on.
Okay, let me repeat. Honorable Garbin, and then Honorable De Lima, Vice Chair Dumogan, Honorable Gonzalez, and then Honorable Abante. And then Honorable Rodriguez. Thank you, Madam Chair. Thank you. You may proceed, Honorable Garbin.
Thank you, Madam Chair. On the first ground, the BBM parametric formula as an institutionalization of corruption. The core allegations of the complainant is that the DPWH approach or the baseline balance manage allegedly shows priorities of leaders to override technical allocations and branding it BBM, and it proves as a presidential corruption framework. Let me state, Madam Chair, that this is not sufficient in substance. Number one, a planning allocation formula is not illegal on its face. Government budgeting necessarily involves policy priorities. The phrase priorities of leaders, even if quoted, is not proof of craft. It is consistent with political accountability in appropriations, especially where Congress itself sets national priorities. The complaint does not cite a constitutional provision prohibiting executive consideration of policy priorities in infrastructure programming. Second, no pleaded fact shows that the President authored, ordered, or used the formula to commit a corrupt act. The complaint infers presidential culpability from branding BBM and from the existence of managed stage. That is not ultimate facts, Madam Chair. It is an argument. Third, no annex authentic DPWH document is shown in the filed copy. The complaint quotes and footnote sources, but the filed copy provided does not attach the complete DPWH policy issuance as a certified annex for committee verification. Without the annexes, the committee is being asked to accept the complainant's characterization rather than reviewing the underlying document. So my take on this, Madam Chair, is at most this pleads a policy critic. It does not plead an impeachable offense nor a willful constitutional breach. Thank you, Madam Chair.
Thank you.
Madam Chair,
The Honorable Tino.
yes, this is just with regard to the observation of the Honorable Garbin that...
You may proceed.
Thank you. That the observation of the Honorable Garbin that the complaint was submitted without annexes for the information of the committee, if it is not yet aware, the complaint was submitted with annexes in a USB format and it was sealed by, in an envelope by the Secretary General or the Office of the Secretary General when it was received. And among the annexes is the complete document of the BBM parametric formula, among others. No, so let me correct that wrong information that there are no annexes. There were annexes officially submitted, and we hope that the committee will provide the annexes to the members themselves for their appreciation. Thank you, Madam Chair.
The committee notes of the manifestation of the Honorable Tino with respect to the submission of the said annexes. Next to manifest is the Honorable De Lima.
Thank you, Madam Chair. Good morning to my colleagues. Before I comment on the first ground of the Maza et al. Complaint, I just wish to state that the first two speakers, the two members who first spoke earlier, actually dwelled already on the entirety of the complaint. So it's good for the Honorable Chair to clarify that we are tackling at this point the first ground. Second po, kailangan rin po malinawan, the Honorable Chair stated yesterday very clearly that in the course of our voting, the Honorable Chair said, the committee would vote on the entirety of the complaint, but not on the specific allegations. Tama po yun. I agree na dapat ganun po ang tingin natin later kapag narinig na natin lahat tungkol sa three allegations. Three factual allegations supporting the general ground of betrayal of public trust. Kasi yung first act of betrayal of public trust, second act, and then the third act. Ganun po. Kasi nga po, baka po meron ilan sa atin ang tingin sa isa ay sa isa may mga certain allegations na hindi naman talaga ultimate facts, but more of conclusion already. But whether or not that's the case, ang importante, ang analysis po natin ng buong complaint is that it would show that there is sufficiency in substance in the sense that there is a recital of the acts constituting the offense charge. So may I proceed, Madam Chair, sa aking analysis po?
You may proceed, Honorable De Lima.
Ng first factual ground, betrayal of public trust. First act, institutionalizing systemic corruption through the BBM parameters formula of allocables. At just like po yung pag-analyze ko po kahapon doon sa first or the De Jesus complaint, meron po ako mga nakita na mga ilan-ilan, or I need to point out ilan-ilan na mga sub-allegations. The first one, DPWH adopted BBM parametric formula for allocating 545.6 billion in flood control appropriations for 2022 to 25. As a result, UA exploded, that's the unprogrammed appropriations, exploded from 251.6 billion in 2022 to 807.2 billion in 2023. I consider this, Madam Chair, a sufficient factual allegation. I will say later my general comment on this, on the first ground. The second sub-allegation, the managed stage of the parametric formula admits that political patronage determine allocation of funds. To me, this is a conclusion derived from the language of the BBM parametric formula and not a factual allegation. Third, contractor testimony confirms the BBM parametric formula as a kickback scheme where DPWH officials demanded 10 to 25% and congressmen 25% paid in cash. This is an allegation sufficient as to the fact of kickbacks. Again, may I just emphasize po, pag sinabing allegation, allegation lang on the face of the complaint, na kapag paniniwalaan natin, which is not necessarily true or will turn out to be not necessarily true, ay sufficient na. Yun po ang ating standard at this point. Meron ho kasing mga nalilito na sa pag-discuss nitong very issue of sufficiency of substance ay kailangan ng delve na kaagad doon sa meron bang ebidensya, tama ba yung ebidensya. Hindi po yun ang tinitingnan natin, at least at this point. I must say that, Madam Chair, because upon review of the rules of procedure, etong sa atin ngayon is just really on the sufficiency in form and substance. There is, and then subsequently, meron din nakalagay sa rules of procedure na kapag halimbawa we find the complaint as sufficient in both form and substance. Papasagutin na natin yung respondent, and then pwedeng mag-comment mag-reply yung complainant, and then pwede rin mag-rejoinder yung respondent. At pwede rin silang mag-attach ng mga affidavits and other evidence dyan sa mga pleadings na ating i-require or the rules require sa kanila. Pagkatapos pong nandyan na yan lahat na pleadings, lahat ng mga supporting documents, if any, including affidavits, there is another stage po dito sa committee, dito sa ating committee, sa committee level. At yan po ay to determine whether the complaint alleges sufficient grounds for impeachment. So separate pa po pala yung pag-determine natin o pag-decide kung ito ba ay sufficient grounds bago magkaroon ng evidentiary hearing kapag the committee's finding is in favor of sufficient grounds. Yun po ang aking pagkakaintindi, kaya ka po linilinaw po ito lahat. That's why my analysis, as you can observe, is focused really on that, the sufficiency of allegations. Another sub-allegation po, going back po sa analysis ko po. Contractor testimony confirms the BBM parametric formula as a kickback scheme where DPWH officials demanded, nasabi ko na po pala ito, demanded 10 to 25% and congressmen 25% paid in cash. Allegations sufficient as to fact of kickbacks, but remains a conclusion as to parametric formula as the cause. Conclusion po yan. Pero meron factual allegation. Another, managed stage of parametric formula, cost award of 1/5 of 545.6 billion to 15 contractors / favored entities. Again, I see this as allegation sufficient as to fact of award, but is a conclusion as to parametric formula as the cause. Yung factual allegation, meron ng conclusion. But does it defeat the existence of the factual allegation? Does it mean na wala ng factual allegation? Hindi ho, ganun ang conclusion natin. Meron factual allegations, meron lang conclusion na nakahalo. Next, parametric formula caused geographic distortion of flood control projects into dumping grounds without master plans. Again, sufficient as to the fact of geographic distortion. Again, allegational lang po. Hindi ko sinasabing yan na yan. Totoo na yan. But is a conclusion as to parametric formula as the cause. Another, parametric formula as designed to facilitate corruption was deliberate. Para sa akin po, conclusion na po ito, not a specific factual allegation. Doon naman po, the last factual point that I need to show, parametric formula centralized and syndicated system of plunder, enriching PBBM, the cabinet, and Congress leaders. Again, this is a conclusion, not a specific factual allegation. In general, for the first ground, I find the specific factual allegations, even without the conclusive statements derived from them, actually establish a probable nexus. So merong specific factual allegations, may kasamang conclusions. In the end, it's still established for me. The nexus is there. Establish a probable nexus. That's for the first ground, Madam Chair. Sufficient.
Honorable De Lima, does that complete your manifestation for the first ground?
For the first ground, Madam Chair.
Can we finish first all the manifestations for the first ground before we call you for the succeeding grounds?
Yes po.
Thank
First
you.
ground.
Now we recognize the Honorable Vice Chair Dumogan. Again, this is for the first act of betrayal of public trust on the BBM parametric formula of allocables.
Thank you, Madam Chair. First, the complainants had verified that they have factual knowledge of the allegations. As it is coming out the allegations from paragraphs 5 to 65 do not show that they have factual knowledge. It's based on second information. I do not like to belabor on that point. I do not like to repeat what our distinguished colleague De Lima had stated. Yes, it can be if there is a factual allegations, but it does not link the president, because what we are obligated to find out is sufficiency in substance that will link the president, that will justify the prosecution of the president on an impeachable offense. It will be prolonging the agony if we will just keep on admitting this and go to the steps if we know from the documents and from the allegations submitted that there is no direct allegations and evidence that can link the president for the commission of legal infraction which is interpreted as impeachable offense under our Constitution. I had reviewed the allegations paragraphs per paragraph, and it is my humble submission that on ground number 1, institutionalizing system corruption through the BBM parametric formula, I cannot find evidence that will directly link the president for having committed an impeachable offense. Yes, we condemn corruption that been committed. I'm sure that all of us are to that point. But our function is to determine whether there is an impeachable offense in the determination of sufficiency in substance that should justify the continuation of the proceedings that will reach the impeachment trial, which at this point in time, on this first ground, as I said, I respectfully submit that I cannot find one. I do not like to say it one by one. My justifications on this point because of limited time. But if it is necessary, then by all means, we will do it. I respectfully submit.
We commend Vice Chair Dumogan for reading paragraph 5 to 65. Moving on, we recognize the Honorable Mika Gonzalez.
Thank you, Madam Chair. Madam Chair, I would like to respectfully manifest to this honorable committee that the impeachment complaint filed by Lisa Masa et al. And endorsed by the Makabayan Bloc is insufficient in substance due to lack of personal knowledge and authentic records. There is zero evidence, documentation, or allegation in the complaint to show that President Marcos authored, participated, or even issued any marching orders for the implementation of the baseline balance managed parametric formula. The complaint is flawed due to the absence of any affidavit of witnesses with personal knowledge and authentic records of the alleged acts. Furthermore, the mere existence of a parametric formula alone fails to meet the threshold of an impeachable offense under the Constitution. In addition, Madam Chair, the complaint fails to provide a recital of facts explaining how President Bongbong Marcos institutionalized or participated in a systematic scheme of corruption through the baseline balance managed parametric formula. The President's specific role was never disclosed or included in the allegations. That's all, Madam Chair.
Thank you, Honorable Gonzales. Now we move to the Honorable Benny Abante.
Thank you, Madam Chair. I'm so glad that Congressman Risa is here so that I could be able to somehow answer some of the comments he made, no? But first of all, I'd like to commend the chairman of the Committee on Justice. Ako, gusto ko nang i-close to eh. Pero the thing is, the chairman of the Committee on Justice would like to, yung himayin po niya ang kasong ito. Oo. Para hindi naman tayo sabihin ng taong bayan na minamadali po natin ito. So I really would like to commend the chairman of the Committee on Justice in being fair in doing this. Oh, hindi ko po kinukuha yung suporta niya. Ngayon ito. Before I go to the sufficiency of substance, hindi po ako abogado. Pero nagbabasa rin po ako eh. Di ba? O ito. There are some controlling doctrines and legal basis. Yan legal basis, no? When the issue concerns sufficiency in substance. Ayan. Number one, an impeachment complaint, sa paniniwala ko, is sufficient in substance when it alleges specific ultimate facts. Ayan, ang pagkakaalam ko. Bilang nandito po ako sa Kongreso for the past 15 years. Okay? Which if assumed true, constitute an impeachment offense. For example, like culpable violation of the Constitution, or treason, or bribery, graft and corruption, or other high crimes, or betrayal of public trust. Number two, I'm not trying to lecture you on law. Ito lang po yung narinig ko, nabasa ko, naintindihan ko. Alright? The following must be present. For example, like identification of the respondent as an impeachable officer. In-identify niya ang Pangulo ng Pilipinas, for example, or VP or Supreme Court Justice, whatever it is, or specific acts or omissions alleged. Not conclusions, like betrayal of public trust is standing alone. Ayan. Number three, a clear link between the acts and a constitutional impeachable ground. Facts that show how the acts amount to, for example, bribery, graft, culpable violation of the Constitution. Nangyari. Number four, the time, the place, the context, and the participation. Who did what? When? Where? How? Enough for the respondent to understand the charge and for the committee to assess whether the ground is facially present. Ayan. Number five, not mere general allegations. Kaya po ako nung isang araw, medyo nag-walk out na kasi puro mere allegations na rinig ko eh. Hindi naman pinapaliwanag sa atin kung ano yung sufficient informed. Alright. Ito ngayon, not mere general allegations. Now, we can accept allegations here, pero it must be based on evidence. Hindi lang po allegation po ito. The court has stressed. Nalaman ko lang, naintindihan ko. The court has stressed that, I quote, ang sabi, mere allegation is not evidence. End of quote. Now, the House substance requirement is met only if there is, as I understand, and I quote, a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. Ayan. Yan po ang sabi sa Gutierrez versus House of Representatives Committee on Justice. At LGR number 193459, February 15, 2011. Parang na akong abogado rito. Nagsasite na ako ng jurisprudence. Ha? Ito. Number 4, when corruption, for example, is invoked as an impeachment ground, it, as I would quote someone else who is a legal luminary, saying, must be supported by more than bare allegations. End of quote. An impeachment, ito must be exercised with, yun po yung sinabi ng kaibigan ko, si Congressman Rizzi, due process. Ito pong ating ginagawa ngayon, in fairness with the chairman of the Committee on Justice, na sa akin po dapat nang tapusin ito. Due process po ang kanyang sinasabi dito. And what? And fairness. Sa akin po, hindi na fair sa amin . Fair na po doon sa mga endorsers ng impeachment process na ito . Fair na po yan sa inyo . Ito. Gusto ko na pong panggitin yung issue number 1, no? Issue number 1. Yung tinatawag nating BBM parametric formula na binanggit ng dating Secretary Bunuan. Di ba? Yun ang sabi niya . Sa akin po, hindi sufficient in substance po ito and should be dismissed as the initiatory state for failure to what? To plead facts constituting an impeachable offense as an act or omission of the respondent. Hindi naman po na ipaliwanag yung tinatawag nating BBM parametric formula. Whether it be explained by the former secretary or even explained by the complainants themselves. Na nakalagay po dito. Ito po sabi nila, an indictment of a policy framework. Na gusto ko pong sabihin dito, sufficiency in substance turns out whether the complaint recites facts constituting the charge offense. Not rhetoric, not labels, or even policy disagreement. Dapat ito po ay talagang facts. Yun lang po muna. Yun po yung una kong gusto sabihin at meron pang kasunod dyan. At gusto ko ipangako sa ating Madam Chair, hindi po ako mag-walk out this time.
Thank you for your passionate
Madam Chair.
manifestation. In response to the manifestation of the Honorable Abante,
Yes, Madam Chair.
the Honorable Co is recognized.
Thank you, Madam Chair. Just quickly responding to the previous manifestation, any jurisprudence that cites that yung complaint has to be supported by more than mere allegations or bare allegations. Dahil yan ay galing sa decision ng the Supreme Court, ibig sabihin dumaan na po yan sa trial stage at nahanap sa trial na walang evidence. Pero to reiterate, wala pa po tayo doon. Nasa stage pa lang po tayo ng determination of sufficiency of substance. Kung ang allegation sa complaint, if you take it one by one or the whole, would constitute an impeachable offense. So, meron pa rin talagang pag-deem na hypothetical admissions ang ginagawa natin, granting na totoo yung lahat ng mga sinabi ng complaint, meron bang betrayal of public trust na nagaganap. Once again, to remind lang po the committee and the body na nandun pa lang po tayo, hindi pa po tayo pumapasok dun sa pagsiyasat, the truth of the allegations. And anyway, kaya naman po hinahain dito dahil may confidence yung complainants na kapag we delve into that and we're able to present evidence and we're able to call on witnesses, they're able to submit affidavits, meron pong truth na malalabas. Madam Chair.
Thank you. The manifestation or response of the Honorable Co is noted.
Madam Chair, since na banggit po yung pangalan ko,
The Honorable
I think-
Erize.
Yes, gusto ko lang po, very, very short. Gusto pong liwanagin na wala pa tayo sa stage ng pagpipresenta ng ebidensya na tulad ng sinabi ni Congressman Abante. At yung pong mga sinabi niya na parameters para sa determination ng prima facie ay lahat po binanggit ko. Who? Presidente. What? Yung pong pag-aproba niya ng release ng mga unprogrammed appropriations at pagpayag niya na tanggalin yung mga flagship projects na nagresulta sa pagkalugi ng gobyerno. Pangatlo, when? 2023, 2024, at 2025 national budget. How? Ayun po, yung pagpirma niya. Yun yung importante. At 3 taon. Kaya po, ma-relink natin ito sa isang paglabag, kung tatawagin ko po ito, inexcusable gross negligence. Matinding pagpapabaya. At ito po na particular na offense na ito ay pumapatak sa betrayal of public trust. Yun lang po. Salamat po.
The manifestation is noted. At this juncture, we recognize the Honorable Rufus Rodriguez.
Thank you, Madam Chair. Specifically, the first act or the first ground to impeach the President is under page 18. Charge, paragraph 66. Respondent President Marcos betrayed public trust by institutionalizing a scheme of corruption through the baseline balance parametric formula. That is the charge. That's not the recital of fact. That's the charge. So I expected that after 66, there will be recital of facts that will be able to state in ultimate facts the acts of the President institutionalizing the BBM formula. This is from page 18 to page 23. A clear reading of all the paragraphs here does not even an iota of recital of fact that there is a connection. There is an act of the President to institute this particular formula. How will the President institute something in this country? Administrative Code of 1986. It says the President issues presidential proclamations, executive orders, memorandum circular. There is no recital of fact here that the President has issued such orders are provided for in the Administrative Code of 1986 that institutionalizes the BBM formula. Second, it can be done through indirectly. There is no recital of fact here that the President called officials of the public works of Malacanang to tell them to institute this formula. Nothing. Recital of fact that the President did the act of institutionalizing under the Administrative Code or even indirectly. No recital of fact on that. Now let us go to the particulars. These are now their alleged recital of facts. Page 18, 67 paragraphs. Paragraph 67. About July 2022, with the first month of assuming the presidency, the DPWH adopted, that is their statement, adopted the BBM parametric formula. Because indeed, the Department of Public Works originated, planned, discussed, implemented this formula. Where is the President here? In the planning, in the implementation. No, there is no statement here that the President directed them to adopt a formula. This was solely adopted, Madam Chair. This was solely adopted by the DPWH. And so, this particular of deliberate design of corruption mechanism certainly does not recite a fact to prove, to be able to state that there was institutionalization of this formula. Now, let's go to the others. because clearly it is a formula done solely by the Department of Public Works and Highway. Next, B. Let's go to B, page 20. Let us all go to this. Concentration of contracts, 100 billion to 15 billion favored contractors. Where is the statement here that these contractors were given, directed by the President to Public Works to be given? In fact, Madam Chair, the President himself was the one who exposed these 15 favored contractors, and thank God there is no favored contractor, these 15 in Cagayan de Oro 2nd District. That is why, Madam Chair, this is not a recital of fact to support the institutionalizing of this formula from the President. Next, geographical misallocation given to Bulacan, Oriental Mindoro, Tarlac. Is there a link that the President ordered that this be given to them? None whatsoever. This was all the function, implementation, and planning by the DPWH. So this geographic misallocation is our statements which are irrelevant to the institutionalizing. That is the charge, institutionalization. So therefore, this will fall. There is no sufficiency here in the recital of facts. Then we go to D, betrayal, abandonment of the public good for private enrichment. Here, we can see here that once again, the systemic betrayal has no recital of fact that will show the President's involvement in this particular formula. And then, they go to the conclusion. My goodness, in a complaint, you don't have a conclusion. In a complaint, it already clear it's not a recital of fact because you state conclusion, corruption was systematic, not incidental. Conclusion of law not based on fact. That is on page 22. That is paragraph 92 to 93. And then we go to page 23. Now, legal conclusion. Now, these are now conclusions of law, which we will all disregard. Because when we go to a complaint, we go to the ultimate facts constituting the offense charge. So therefore here, it concludes, conclusion of law without any basis. It says, respondents Marcos institutionalization of the BBM parametric formula constitute betrayal. There is no link. Their conclusion jumps from the charge, paragraph 66, to paragraph 94 without any link of the President. And that is why, Madam Chair, clearly, the first ground of betrayal of public trust is not sufficient in substance. And this particular allegation should fall. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. At this point, we recognize the Honorable Janice Digamo. We are still on the first offense, institutionalizing systemic corruption through the BBM parametric formula of allocables. You may proceed.
Yes po. Good morning to everybody. I would like to express how I understand the procedure, lalong-lalo na doon sa unang grounds na binabanggit. At being a non-lawyer, I have to aralin po kung paano ko titignan yung sufficiency in substance. And sa akin pong pagre-research, lalong-lalo na ngayon na narinig ko si Congressman Rufus, pag ina-assess natin yung sufficiency in substance on the first allegation, natutunan ko that I have to look for the act, the document, and the violated duty. So dun sa first allegation, yung BBM formula is the act. But you will have to ask the question, who committed the act? Is it the President himself? Alam po natin, in-explain po ni Kong Rufus na hindi naman po. Ano yung document to support it? Nandun ba yung document to support the allegation? Dapat hinahanap natin yan pag nag-judge tayo according to the sufficiency of substance. At ang pangatlo po, yung violated duty. With the BBM formula and yung implementation has nothing to do with the office of the president or the president himself. Paano magiging si presidente ang person to be blamed para dito sa sinasabi natin na BBM formula? You cannot see the hand of the president in all this accusation. Lalong-lalo na dito sa unang sinasabi nila ni BBM, the BBM formula. I think we have to go back to DPWH dahil sila yung nag-i-implement ng programa. Pwede kasi na ang intensyon ng presidente for giving the budget is very good. Pero yung nag-i-implement ang nagiging problematic. So saan yung kamay ng presidente doon? Yun yung hanapin natin dapat. So yan lang po. That's my peace of mind, Madam Chair. Thank you po.
That manifestation of the Honorable Digamo reminds the Chair to encourage the members to speak in a language where we will be understood by our beloved countrymen, no? This is actually the power of the sovereign people, and I hope that through this public hearing, we are able to communicate where this power truly rests, no? So we encourage the members as much as possible to speak in Filipino so the people will understand us. Thank you, Honorable Digamo. This is still on. All right. In response to Honorable Digamo,
Yes.
we
On
recognize
the
the
comments
Honorable...
made by the Representative Rodriguez and Representative Degamo.
All right.
As well as earlier, the Representative
The
Labas.
Honorable Ilago is recognized.
Yes. Madam Chair, tungkol doon sa first act ng betrayal of public trust, doon sa pagpapatupad, pag-implementa ng sistematiko na korupsyon sa pamamagitan ng baseline balanced managed parametric formula of allocables. Ang charge po doon sa complaint nakalagay na ang respondent, President Ferdinand Bongbong Romualdez Marcos Jr. betrayed public trust by institutionalizing a systemic scheme of corruption through the adoption and implementation of the so-called baseline balance managed parametric formula as the official allocation mechanism for flood control and other infrastructure projects, thereby converting the national infrastructure budget into a centralized apparatus for plunder. Kanina pa ho sinasabi na DBM naman ang nagsulat niyan, DPWH naman ang nagsulat niyan, ang author, DPWH naman ang nag-implement. No? Pero ang hindi po sinasabi dito, no, sa ilalim din ng ating konstitusyon, ng ating saligang batas, Section 17 of Article 7, the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. And corollary to this is the doctrine of qualified political agency, aka the alter ego doctrine, which the Supreme Court explained that the President's power of control is directly exercised by him over the members of the cabinet who, in turn, and by his authority, control the bureaus and other offices under their respective jurisdictions in the executive department. Ang bottom line, Madam Chair, tulad ng nabanggit din ng ating mga complainants doon sa nakasaad mismo sa complaint sa paragraph 67, page 18, na noong July 22, 2022, noong first month pa lang na nag-assume ng presidency si Pangulong Bongbong Marcos, ang DPWH nga ang nag-adopt nitong BBM parametric formula bilang official methodology for allocating the unprecedented 545.6 billion in flood control appropriations mula noong 2022 hanggang 2025 no budgetary cycle. Nandyan din ho paragraph 92, page 22, yung alleged kickbacks na predictable at intended consequences ng institutional design choices mismo ng respondent sa pamamagitan ng BBM parametric formula. Paano, Madam Chair? Ang bottom line dito, yung mga written internal policies na adopted and implemented by the agency by virtue of the qualified political agency, siya po dapat yung lahat ng ito ay attributable mismo sa presidente. unless meron talaga siya na express, na written, na nagsasabi na ito ay kanyang hindi inaaprubahan o ito ay or merong disapproval mismo ng presidente. At yun yung hindi natin nakita. Bagkus, nakita pa natin na ito ay nagpatuloy at nag-cause ng malawakan, sistematiko na korupsyon na nagbigay daan doon sa malawakan na pagnanakaw sa pondo ng ating bayan. Kaya, Madam Chair, kami po ay naninindigan na merong personal na involvement. Ito po ay may basbas ng Pangulo at hindi ito magiging posible kung hindi mismo pinayagan, sinusugan ng Pangulo mismo.
The manifestation of the Honorable Ilago is noted. Our
Madam
last
Chair.
speaker for the first offense, the Honorable Padiernos.
Madam Chair, and afterward.
Let us finish first with the manifestation of the Honorable Padiernos, and then we will be calling the Honorable Co.
Thank you, Madam Chair. So, just a quick manifestation. Madam Chair, after carefully reviewing the complaint and with respect to the first allegation on the so-called BBM parametric formula, this representation is in the position that the allegation is insufficient in substance. Una po, walang batas at walang jurisprudence na nagsasabing illegal ang paggamit ng isang budgeting or allocation formula. Pangalawa, wala ring ipinakitang dokumento na nagsasabi na personal na nilikha o inutos ito ng Pangulo. While the recital of facts could possibly constitute the offense charged, the allegations do not point that as to the formula, the same is attributable to the President. The allegation in paragraph 91 stating that, and I quote, the scope and scale of this corruption spanning multiple senators, cabinet secretaries, undersecretaries, district engineers, contractors, and intermediaries could not have operated without the institutional architecture created by the respondent, is at most presumptive or speculative. Even if cabinet secretaries are alter egos of the President for purposes of executive control, the doctrine does not automatically convert every administrative issuance into a personal culpable act of the President. In this case, the complaint does not allege that the President directed, approved, ratified, or even knew of the question policy, much less that he acted in bad faith. Malinaw po to sa ating jurisprudence under Estrada versus Desierto and Gutierrez versus House Committee on Justice. Impeachment requires a personal overt act and culpability. The alter ego doctrine cannot supply what the complaint fails to plead. Dahil walang illegal act na na-plead personally against the President, this does not constitute an impeachable offense. Again, Madam Chair, I just want to reiterate, the recital of facts as mentioned for the first allegation could possibly constitute the offense charge or betrayal of public trust in this case. But we have to also consider, does that offense, is it personally attributable to the President himself? And this representation is in the position na in the negative po. So yun lang po, Madam Chair.
Thank you, Honorable Padiernos. Now let's hear the comment from Honorable Co.
Thank you, Madam Chair. Madam Chair, just to reiterate the discussion of Representative Sara Elago, we talked about kanina yung doctrine of qualified political agency. Ito ay well-established in jurisprudence. Ang sinasabi lang naman po nito, yung acts of department secretaries, presumed yan na acts of the chief executive or the president, no, unless disapproved. At ang may burden ng showing kung may disapproval man or hindi, nasa challenger, no. So una po, nasa attachments po natin yung tinatawag na BBM parametric formula. This is a 16-page document which says, no, that this formula was used para i-prepare ang 2023 National Expenditure Program. At ano po yung act of the executive that validates yung use of this formula? No? It is the signing of the NEP. In fact, kung i-extend pa natin, no, meron pong, we could take judicial notice of the claim by now DPWH Secretary Vince Dizon that in the preparation for the 2027 NEP, they will not be using the BBM parametric formula anymore. That is an implied admission na even up to the 2026 NEP ay may ginagamit pa rin po yung parametric formula na ito, which says that the priorities of leaders of the national government will be considered in approving infrastructure budgetary allocations, no, yung matatawag nating allocables. In fact, meron din po tayong attachments in the complaint which says, no, and tags NEP items. They are for OP, ES, SAP, indicating presidential involvement in implementing the formula for allocables. So ibig sabihin po, this presumption, no, may presumption na itong act ng secretary na doon po sa formula, clear po sa document na galing po ito sa Office of the Secretary. So we assume na act po ito ng President. And then yung act of the President of signing the GAA 2023 onwards validates po yung use of the formula. Yun po ay alleged in the facts of the complaint that is recited. And so ito po yung pinopropound natin, no, na at the end of the day, may tag budget items and NEPs and allocables for OP, and thus, no, magsastand po yung argument. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Rodriguez and then the Honorable Abante.
The doctrine and the presumption of qualified political agency was pronounced by the Supreme Court in the case of Planas versus Hill, Montaño versus Silvosa. I cannot forget that first year law school. And in that case, precisely, it's a presumption. Because then it can be rebutted by evidence. Now, it would have been incumbent on the complainants that they will be able to strengthen this presumption by putting up a link of qualified political agency, alter egos of the president in terms of implementation of the public works to implement. He is the alter ego being a secretary. That is a presumption that everything is done correctly. Now, it would have been incumbent of the complainants to be able to show and strengthen this presumption by saying that this particular qualified agency was, in fact, directly, it's not anymore a presumption because they're alleging that it is direct. It is not anymore presumption because they are now charging that there is institutionalization. So therefore, the case of Planas versus Hill and Montaño versus Silvosa, they can research that now because I just remembered it. First year law school. Now, therefore, they cannot hide now, the complainants cannot hide now under the cloak of that presumption because they are now filing a case against the president. And so therefore, everything in the face of the documents there should be a recital of facts. So the presumption cannot hold anymore because they are now filing the case. And they are now saying that this is not only a presumption, it is done and it is what is that the president is linked to the institution, which there is no recital of fact on that. Thank you, Madam Chair.
Thank you. Next is the Honorable Abante.
Madam Chair, the explanation of Congressman Rufus is actually more than enough. No? Pero I'd like to add to this. No? Ito naman tinatawag nating the doctrine of command responsibility, where we say that the act of the secretary is the act of the president, and the act of the department heads is the act of the secretary. Ano ha? Yan po'y general rule eh. General rule po yan. But there is always exception to a general rule. For example, sa akin po sa akin, alter ego is not immunity. But also not strict vicarious criminality. unlawful acts are not acts of the state. And liability analysis remains individualized for wrongdoing. Kaya nga po iniimbestigahan pati ang Secretary Bonoan eh. Kaya nga po tinanggal. Kaya nga po may kaso. Bakit pinabayaan ng ating Pangulo na kasuhan niya mga yan? Kung siya po ay talagang author ng lahat ng mga nangyayaring yan. Therefore, ito po itong number 1 na ito, the argument na binigay sa atin, with due respect to Congresswoman SARA, at po na talagang mga close din sa akin to mga to. No? Pero the thing is this po, kinakailangan malaman po ng taong bayan na hindi po ito yung absolute rule. Oo. General rule po ito. At naniniwala po tayo na ang unlawful acts ng sinumang alter ego ng Pangulo, hindi po ito act ng Estado. Kaya nga po ito'y iniimbestigahan. Kaya nga po naniniwala ako na hindi po ito nauukol sa tinatawag nating sufficiency of substance. Thank you, Madam Chair.
Madam Chair. Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Maikling mga manifestation lang po. No? Una po, malinaw at direkta po ang recital at pakahulugan dun sa unang bahagi ng betrayal of public trust, institutionalization ng allocables at sistema ng corruption sa pamamagitan ng BBM parametric formula. Ano po ang akto? Malinaw na po kahit dun sa title mismo, high level ng dokumento na kasama po sa mga attachments at official na dokumento ng DPWH. High-level budget allocation formula, the baseline balanced managed parametric formula adopted in 2023 National Expenditure Program preparation. No, yung National Expenditure Program, yun po, ang tawag nga po dyan, the President's Budget. No, so ito yung budget na nilalagdaan ng Pangulo at sinasubmit sa Kongreso at itong nagiging batayan ng General Appropriations Bill. So yun po yung malinaw na sinasaad dito na ibig sabihin ng institutionalization ng sistema ng korupsyon. At nais ko lang pong ipaalala na hindi lang naman po yung policy na yon ang batayan ng unang bahagi. Kasi sasabihin niya, policy lang naman yan. Anong masama dyan? No? Kaya nga po kasama rin po dito yung mga testimonya, sinight yung mga testimonya ng mga whistleblower, kasama si Yusek Bernardo at ilang mga kontraktor, at nandun din po sa complaint, sa attachments, yung mga records nun na nagsasabi na ito ang naging basis ng kickback no, ng mga ghost projects, substandard projects, kickbacks and commitments. So yun po ang buong recital. Kaya sinasabing may betrayal of public trust ang Pangulo. Yun lang po ang gusto nating ilinaw dito.
Of course, we value the long-standing principle of law, no? As a matter of fact, that qualified political agency is considered as one of the landmark cases, and you will agree with me. However, the Honorable Padiernos made mention about one jurisprudence which provides there has to be personal, overt, culpable act to constitute an impeachable offense. I would just like to give this chance to the Honorable Ko if she wishes to comment to that as well.
Thank you, Madam Chair. To us, no, it is clear na yung act na po yun is signing of the budget. No? Passing the budget and then later on signing the budget. Na ginamit po doon yung BBM parametric formula to be able to distribute yung system of allocations.
We note the answer of the Honorable Ko. So
Madam
that
Chair, I just wanted to add on
Honorable Padiernos.
the alter ego doctrine. Madam Chair, the alter ego doctrine only creates a presumption in terms of administrative purposes. It does not establish personal culpability for impeachment. Kasi kung ganun lang din po, di lahat na lang po ng cabinet memo na in-issue, kung nagkamali in the future, sinabing mali, eh lahat na lang po yan pala impeachable offense. So it sets a bad precedent or precedent that, you know, if the president would be silent on matters like such as this, then automatic guilty na po siya. Parang ganun po yung dating. So yun lang po, Madam Chair.
Madam Chair,
Honorable Tino.
just reply to that. Yung sinasite po na jurisprudence with respect to delegated authority and so on, this is with regard to criminal liability. No? Pero ang pinag-uusapan po natin dito ay betrayal of public trust. Kaya nga, sabi nga kanina, acts that fall short of criminal acts. Kaya hindi po nag-a-apply yung binabanggit niya rito, no, dahil ang pinag-uusapan po natin ay acts that fall short of a crime, an actual crime. No? Yun lang po ang gusto nating ilinaw.
Thank you, Honorable Tino. And as our last speaker, last to comment on the first offense is the Honorable Digamo.
Thank you po, Madam Chair. Madam Chair, when the President affixed his signature, malamang po bilang Presidente, ang iniisip niya yun talagang this will do good. These projects, this fund will be translated into projects that will protect lives and properties. Inaasahan po ng Presidente na magiging maganda ang gagawin ng agency kung saan pinaglalaanan niya ng pondo. Bakit ko po ito nasabi na the allegation lack in substance? Because wag po nating kalimutan that during the SONA, the President himself called the attention of those hearing officials na sa paniniwala niya, nagkandasira-sira ang maganda niyang plano dahil sa maling pag-i-implement po. I hope everybody in Congress will remember that ni-remind ng Presidente. Kaya hindi ko po makita yung kamay niya dito dahil siya mismo nag-remind kung paano, anong ginawa niyo sa pinagkatiwala ko sa inyo. Thank you po.
This should be the last of the last.
Yes,
The
Madam
Honorable
Chair.
Elago.
Opo, we cannot and should not speak for the President. Kaya nga po nananawagan ng taong bayan na maipasa ito pagdating sa sufficiency in substance na para magkaroon na tayo ng hearing, mapatawag yung Pangulo mismo at marinig mismo natin mula sa Presidente yung kanya pong paliwanag kung bakit po nahayaan itong malawakan na korupsyon sa pamamagitan ng adoption at implementation ng BBM parametric formula at yung mismong paglagda niya sa ating pambansang budget. Okay, thank you.
We will be terminating our deliberation on the
Madam
first
Chair.
offense. Of course, we recognize the efforts and contributions of the members for the valuable exchanges of opinions, including principles of law. That concludes our deliberation on the first offense. We will now move to the second offense. Second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriations. Now we elicit the opinion, position, comment from the members. The Honorable Adyong.
Thank you. Thank you very much, Madam Chair. Bismillahirrahmanirrahim. Madam Chair, I understand that the direction of the committee is to compartmentalize the issues or the complaints under the Masa et al. Complaint, Madam Chair. But allow me first to at least touch on the first issue that was discussed earlier. And I understand, Madam Chair, that many of our members here, many of the members here have already spoken and expressed their manifestation regarding the first offense or the first complaint that was discussed. So my approach, Madam Chair, on these complaints, on how I understand it, is based on not necessarily on a legal perspective, because many of us here in the committee, I understand, are non-lawyers. So our approach here is, first of all, we based our observation on what is guaranteed in what are laid down in the Constitution that would constitute impeachable offenses. Number two, based on how the public would perceive these proceedings. Kasi ordinaryo pong tao nakikinig po sa atin. Minsan po hindi maintindihan kung ano po yung mga pinag-uusapan dito, and we cannot fault them because these terms, recital of facts, admissibility of evidences, these are legal terminologies that we can often see and hear them during a regular court proceedings. So my position here, Madam Chair, and the way I approach this is based on coming from an ordinary, average-minded Filipino. Madam Chair, the allegations stated in the complaint, to me, do not constitute betrayal of public trust. In an alleged violation of public trust, the alleged acts must be short of criminal. Tama po yung sinabi po ng aking kaibigan, Congressman Tino. However, the allegations as to receiving supposed kickbacks imputes a commission of a crime. That is a substantial defect, to my view, in the allegation presented. Because number one, the chosen charge is wholly and fatally inconsistent with the alleged act. There's a claim of direct personal involvement, but the same is merely conclusory and unsupported by sworn statements, documentary evidence, or the personal knowledge of the complainant. Meaning to say, Madam Chair, if there's a complaint in the impeachment proceedings such as this, while we are actually appreciating the sufficiency of substance, there has to be at the very least a link between the alleged crime committed and the person that is being accused directly ordering these crimes. This is borne, Madam Chair, out by the superfluity of general accusations, assumptions, and inferences, and the lack of identifying dates, specific transactions, responsible officers, or any overt act personally attributable directly to the President. Wala sa complaint mismo, Madam Chair, ang mga personal at direktang aksyon ng Presidente na magiging basihan para sa nirereklamong charge. There is not even a direct allegation to explain how these alleged kickbacks reached the President. Madam Chair, hindi po dapat gamitin ang impeachment proceedings bilang fishing expedition at hindi maaaring gamitin. Para sa akin, as stated earlier by my colleagues, the mere essence of a principle of command responsibility lamang o ang policy decision bilang basihan ng impeachable offense without necessarily, again, linking the President to personally ordering his subordinates to craft a policy that would be considered a direct culpable of the Constitution, constituting therefore an impeachable offense. In fact, Madam Chair, the Supreme Court has stated that the betrayal of public trust must refer to direct and personal acts by the accused. Number one, basic, Madam Chair, is to establish bad faith. The complaint relies heavily on singular, unverified, and unsworn testimonies, Madam Chair. The alleged testimonies do not meet on any material point that would establish direct, personal, and intentional participation of the President. In the Supreme Court decision, Madam Chair, cited by the complainants, which held that special provision from the GAA was unconstitutional for being a rider and for impliedly repealing the Universal Health Care Act, the court also denied to pass on the liability on the Department of Finance. In fact, Madam Chair, individual justices in their decisions stated that the Department of Finance followed the challenged provision in good faith. So there's no culpability even if you look at the ruling of the Supreme Court. that the finding of good faith defeats, Madam Chair, the accusation of betrayal of public trust because the same requires attendant grave and serious bad faith. There is no factual chain of culpability kung pagtatagpi-tagpiin po natin ang mga ebidensya na sworn, competent, at admissible. Hindi may papakita na mayroong partisipasyon po ang presidente. Yun po ang basic na tanong ng ating taong bayan. To allow such fragmented and legally infirm allegations to substantiate an impeachment complaint would dangerously lower the constitutional threshold for impeachment. It would weaken the impeachment process, as explained to us extensively by the able chairperson yesterday. To allow barefaced and unsupported claims which do not directly implicate the respondent as basis for impeachment would erode due process, weaken institutional safeguards, and expose impeachment to abuse as a tool for political harassment and, I'm afraid, Madam Chair, destabilization. For all of these reasons cited above, I find that the allegations, Madam Chair, with due respect to my friends, do not constitute a betrayal of public trust. Marami pong salamat sa Madam Chair. Magandang umaga po sa ating lahat.
Thank you, Honorable Adjong. Now we recognize the Honorable Lordan Suwan.
Prohibited by law. In fact, they are referenced in Section 35, Book 6 of the Administrative Code. And so, presidential approval of the release of these funds does not equate to discretionary indulgence. It is actually a requirement of law. And on another point, the complaint mentions extensively about the case of Pimentel versus House of Representatives. This is regarding the PhilHealth funds. Now, the complaint's reliance on that case, I think, is misplaced. We must differentiate, because that case addressed the constitutionality of a specific funding mechanism in the General Appropriations Act. It did not find any instance of presidential bad faith, corrupt intent, or personal enrichment, nor did it characterize the release of unprogrammed appropriations as betrayal of public trust. Let's remember that judicial invalidation of a budgetary provision cannot be retroactively transformed into an impeachable offense. A ruling against a budgetary provision is not a ruling against the president. Now, the complaint also mentions extensively about the increases in unprogrammed appropriations amounts. And it seems that the complaint would make it appear that there is a grand criminal design, and it was the president who is behind all of this. But in my opinion, there is a much simpler explanation in the increase of unprogrammed appropriations. It might very well be a response to post-pandemic recovery. This is a simpler explanation of this increase. And also revenue contingencies or even disaster-related responses. And regarding alleged irregularities in the execution of projects, this cannot be directly attributed to the president, but can be attributed to guilty or erring implementing agencies and even contractors. So, for me, as to the alleged second act of betrayal of public trust, the complaint falls short, or it appears that there is an insufficiency in substance.
Thank you, Honorable Suwan. Next in line is the Honorable Amben Amante.
Thank you, Madam Chair. The complaint raises unprogrammed appropriation and alleged kickbacks, yet it fails to establish any direct link to the President. Walang claim that he received money or property. Walang claim that he personally benefited. Walang illegal transaction showing personal participation. Walang allegation that he ordered, joined, or colluded in any kickback scheme. References to unprogrammed appropriation do not lead ultimate facts, tying the President to corruption. At law, unprogrammed appropriation are valid under the Administrative Code and were affirmed by the Supreme Court in Bellica versus Executive Secretary. In short, mere pagkakadismaya with how funds were allocated cannot substitute for evidence of personal wrongdoing by the President. Madam Chair, mere policy disagreements, pagkakadismaya with budget outcomes, or speculative allegation cannot substitute for direct presidential wrongdoing. Without ultimate facts supported by clear and convincing evidence, the complaints fall short of the constitutional threshold for impeachment. The question we must ask are simple. Ano ba talaga ang ginawa ng Presidente? Where is the evidence? Where is the law? Until these questions are answered with proof, the charge cannot stand. Thank you, Madam Chair.
Thank you, Congressman Amben. For the guidance of everyone, all the members, we are still on the second offense. That is the unprogrammed appropriations. We have a list here, and next in line is, if he is ready, Honorable Emeng Pascual. You want to be called later.
Here, who are in the list? So that I can include, if I propose to include my name.
Yes. Next to Honorable Emeng is Honorable Alan T. And then Honorable Garbin likewise raised his hand. Honorable Laila de Lima, and then Honorable Rodriguez.
Madam Chair, can you include my name too?
Yes, Honorable Abante. So for the guidance of everyone, Honorable T, Honorable Garbin, Honorable de Lima, Honorable Rodriguez, Honorable Abante. For the information of the Vice Chair Dumogan. For the information of the committee, Honorable Alan T is using a slide, 2 slides to aid him in his expressing his manifestation. Honorable T, you may proceed.
Thank you, Madam Chairperson. The rules of procedure in impeachment proceedings requires that an impeachment complaint be sufficient in substance before it may proceed. Sufficiency in substance demands a recital of ultimate facts and a determination of these facts, if admitted, constitute a valid ground for impeachment under the Constitution. Despite its length and extensive recitation of budgetary figures, testimonial excerpts, and policy outcomes, the second impeachment complaint fails to meet this constitutional threshold. Volume, however, is not a substitute for ultimate facts. The complaint relies on inference rather than personal knowledge, characterizes discretionary policy mechanisms as criminal conduct, and imputes the alleged acts of third parties to the President without pleading specific overt acts personally attributable to him. The allegations are based on hearsay and lack personal knowledge. Section 3, Rule 2 of the House Rules of Procedure in Impeachment Proceedings requires that a verified complaint be based either on complainant's personal knowledge or based on authentic records. A review of the complaint shows that its central accusations rest on the testimonies, interviews, and statement of third parties. None of the complainants allege that they personally witnessed the President ordered, approved, or participated in any alleged kickback scheme. The complaint repeatedly cites Senate testimony, media reports, and investigative narratives to support the conclusion that the President orchestrated a system of corruption. These sources merely recount what other individuals claim to have observed or inferred. Allegations derived from hearsay, no matter how frequently repeated, do not constitute ultimate facts and cannot support a finding of sufficiency in substance. Failure to allege any act personally attributable to the President. Notably, the complaint does not allege a single specific act supposedly committed by the President, despite sweeping claims of institutionalized plunder and betrayal of public trust. Impeachment is not a doctrine of vicarious liability. The President cannot be impeached merely because officials within the executive branch exercise discretion, nor because Congress later disagreed with how such discretion was exercised. Assertions that the President sits as to the top of the bureaucracy or that policies bear his political branding do not establish culpability. What the Constitution requires is a clear nexus between the President's own acts and the alleged offenses, a nexus that is entirely absent from the complaint, as borrowed from the term of Congresswoman De Lima.
We are waiting for your slides.
Yes. Policy disagreements are not impeachable offenses. A substantial portion of the complaint attacks the design and implementation of budgetary mechanism, including the so-called BBM parametric formula, the use of unprogrammed appropriations and fiscal prioritization decisions. These matters fall squarely within the budgetary process. The executive proposes, with the submission of the National Expenditures Program, Congress legislation with the passage of the General Appropriations Act, and budgetary execution by the executive. As stated in the General Appropriations Act itself, unprogrammed appropriations are expressly authorized by Congress and may be availed of only upon the occurrence of statutory conditions and the required certification, underscoring that their use is conditional and not an exercise of unfettered executive discretion. Unprogrammed appropriations are not discretionary funds in the sense alleged by the complaint. The complaint itself cited special provisions on unprogrammed appropriations under the General Appropriations Act. As can be seen from the slides on the unprogrammed appropriations, under special provision paragraph 1, A, B, and C, there are conditions that must be met before you can avail of the unprogrammed appropriations. 1, paragraph A, there must be an excess revenue, new revenue collection, or those arising from new tax or non-tax sources, or approved loans for foreign assisted projects, and only after certification of fund availability by the Bureau of Treasury. As can be seen also, Your Honor.
Point of
that-
order, Madam Chair.
Yes.
There's a point of order from the Honorable Ko.
We just like to clarify that the budget being I'm sorry, point of information rather than point of order.
If that is a point of information, then we should allow him to finish first.
Okay. Okay, thank you, Madam Chair.
All right. The Honorable T, please proceed.
Thank you, Madam Chairperson. Note that unprogrammed appropriations are standby and conditional appropriations that may be only used only upon the actual realizations of paragraph A, B, and C, and certification of fund availability by the Bureau of Treasury. Until these statutory conditions are met, the executive has no discretionary authority to release funds and is further limited by the purposes expressly approved by Congress under the unprogrammed appropriations section of the GAA. Can you show the next slide, please? As to the purposes. As you can see, there are purposes that these funds that can only be utilized for the following purposes as stated in the General Appropriation Act. The executive may not release funds absent the statutory triggers, nor may it divert funds to purposes not authorized by law. Accordingly, the use of unprogrammed appropriations after compliance with statutory conditions and certification requirements cannot be equated with arbitrariness, illegality, or impeachable conduct. To do so would conflate lawful budget execution with criminal intent and collapse the distinction between policy implementation and constitutional violations. Disagreement with fiscal allocation priorities constitute a political or policy dispute, not a culpable violation of the Constitution. To accept the complainant's theory would be transformed impeachment to a mechanism for penalizing governance actions, thereby collapsing the separation of powers and undermining the constitutional design. There is failure also to state a cause of action for betrayal of public trust. The complaint invokes betrayal of public trust as catch-all ground for a collection of administrative grievances and political accusations. However, jurisprudence requires that this ground involved acts so grave and outrageous that they strike at the very core of public office. The complaint fails to allege any document signed by the President ordering unlawful disbursement, any transaction in which he personally received funds, or any commission on audit findings identifying him as a participant in illegal activity. General references to COA observations, Senate inquiries, and media reports do not amount to ultimate facts. The complaint relies on ongoing investigation and Senate inquiries to supply evidentiary support for several allegations, demonstrating that it's not evidentiary complete at the time of filing. Impeachment is not a discovery mechanism. A complaint must be sufficient in substance at the time of filing, not after hearings, subpoenas, or political inquiry. In sum, the second impeachment complaint is long on rhetoric but short on ultimate facts. It relies on hearsays, conflates policy disagreement with impeachable offenses, and imputes the alleged acts of others to the President without pleading direct participation, and are contradicted by the official records such as the General Appropriations Act. To allow such complaint to proceed would erode the constitutional safeguards governing impeachment and reduce it to a tool of political contestation. For failing to meet the rigorous standards of sufficiency in substance, the complaint should be dismissed. Thank you, Madam Chairperson.
Honorable T, would you like to reiterate your argument in showing the purposes in the slide?
Well, the purposes of showing the slides on unprogrammed appropriation shows that there are conditions to be met before the unprogrammed operation can be availed. So there are conditions to be met as provided for under paragraph 1A, paragraph 1B, and paragraph 1C.
All right.
Likewise, Madam Chair, if I may proceed.
Yes, please continue.
Also, as to the increase on unprogrammed appropriation, the complaint itself in page 9, paragraph 28, and if I may quote, on December 11, 2023, this is in reference to the GAA General Appropriation Act 2024, the Bicameral Conference Committee, referring to Congress, submitted a report that drastically altered the President's original proposal, meaning the increase in the unprogrammed appropriation from the proposed 281.9 billion to a staggering 731.4 billion, an increase of 449.5 billion was through the act of Congress. Likewise, in the very same complaint, to fund this explosion, as I quote, the committee, referring to the Bicameral Conference Committee, inserted a special provision 1D, authorizing the use of fund balances of government-owned and controlled corporation. Meaning, Madam Chairperson, it's not the President who increased the allocation of the unprogrammed appropriations. It is the act of Congress by the Bicameral Conference Committee that increases the budget allocation in the unprogrammed appropriations. Thank you, Madam Chair.
Thank you, Honorable T. Your quite lengthy manifestation is duly noted. Now we recognize the Honorable Garbin. There's a list, Honorable Chua. You will be after the Honorable Abante.
Thank you, Madam Chair. Let me proceed with my manifestation on ground number 2. the expansion and use of the unprogrammed appropriations as a shadow budget. The core allegation of the complainant is that the UA, or the unprogrammed appropriation, grew dramatically. Releases supposedly required presidential approval, and therefore, the president personally enabled the corruption. Why is it not sufficient in substance? First, Madam Chair, as correctly put up by Congressman T, the UA is a statutory budget mechanism enacted by Congress. The UA exists because Congress places it in the General Appropriation Act. The growth in the UA by itself is not unconstitutional. The complainant or the complaint does not plead which constitutional limit was violated merely because UA amounts increase. Number two, no pleaded facts identify any UA-specific release that was illegal. The complaint cites aggregate figures and percentages, but does not identify. First, the specific UA item release, the condition precedent for the release, how those conditions were absent, and the issuance of the SARA or the NCA that prove its illegality. Madam Chair, even assuming the Supreme Court in the case of Pimentel versus House of Representatives found parts of the 2024 budget mechanism unconstitutional, that ruling does not establish an impeachable offense by the President. In the Supreme Court, dispositive portion ruled that the presidential certification of its urgency as not unconstitutional. And even if it were for the sake of argument, Madam Chair, such act in itself does not amount to an impeachable offense. It is just merely a democratic mechanism of checks and balance. The case addresses the special provisions, specifically paragraph 1D and its DOF implementation. It does not supply the project level facts, procurement irregularities, the kickback transactions, or any willful bad faith. The complaint still asks the committee to jump from unprogrammed appropriations figures to corruption conclusions without the required linkage. On that basis, it remains, Madam Chair, that this allegation is insufficient in substance. Unconstitutionality of a provision is not by itself betrayal of public trust. Betrayal requires pleaded ultimate facts showing grave misconduct attributable to the President. The complaint uses unprogrammed appropriations, expansions as an insinuation, but it does not show willful bad faith, corrupt purpose, or direct presidential participation, nor does the SC ruling fill those gaps. Madam Chair, thank you.
Thank you, Honorable Garbin. Next in line is the Honorable De Lima.
Thank you, Madam Chair. Before I present again my own analysis of the second ground, I wish to state these observations. Well, one or two of the previous speakers again dwelled on the entirety of the complaint, and that includes the Honorable Representative Zia Alonto. And I cannot also help observing that about a couple of the previous speakers are actually dealing with the defenses, the possible defenses on the part of the respondent. Yung pagkakasabi po, with due respect to the Honorable Congresswoman Degamo, that the President must have been motivated by the desire to address the public good. That is a defense. Another one is on the part of what was stated by the Honorable Representative Suwan, that the increase can very well be, maybe explained by the fact that this was during the pandemic period. Again, that is a matter of defense. Kaya nga po, paulit-ulit ko pong sinasabi sa lahat na analysis ko po, nang tinitingnan lang po natin dito is the sufficiency in substance. And then, just to also address the point of the Honorable Congressman Ting, he pointed to paragraph 28. On December 11, 2023, the Bicameral Conference Committee submitted a report that drastically altered the President's original proposal. So his contention is that it's not the act of the President, but the act of Congress through the Bicameral Committee. Pero hindi ho ba meron allegation sa complaint? And I think this is pages 40 to 41. I'm sorry, paragraph 40 to 41 and paragraph 50 to 51. Ang natatandaan ko pong nakasabi dyan, during the Bicameral Conference Committee deliberations in 2024, PBBM instructed DBM Secretary Amena Pangandaman to insert 100 billion worth of projects during the BICAM. Another allegation, related allegation, PBBM produced a list of projects worth 100 billion for insertion. This list was given to executive and legislative officials involved in the BICAM. So nobody can really say that the President's hand is clean with respect to those insertions, additional amounts included in the GAA as deliberated upon by the BICAM. So again, allegation. Hindi ko po sinasabi, totoo yan. And then, nakikita ko rin po sa discussion under ground 2, page 25 and page 26, or even part of 27. The complaint actually made a causal link to corruption. Meron po sila mga diniscuss dito. Several circumstances, which include the allegation that the top UA-funded contractors are now under criminal investigation. Kasi sila po yung mga supposedly reveal ng Pangulo, pero sila yung mga top UA-funded contractors. And these 4 contractors, yung Sunwest, Silver Wolves Construction Corporation, High Tone Construction, Newington Builders, received a combined 18.44 billion in UA-funded contracts. Funds released only
Madam Chairman.
because respondent
Madam Chairman.
personally approved the special budget authorizing
What
the
is the
disbursement.
pleasure of the Honorable SDML
With due
Defensor?
respect to the Honorable De Lima, may I raise a point of order?
You're recognized, SDML.
I respect the position of the Honorable De Lima, but we must also remember that every impeachment complaint, every impeachment hearing, regardless of who the respondent is, it is a political process. It is political in nature. And let's allow the members to speak what they have to say. We will not interrupt any member. We will not interrupt the Honorable De Lima. Let them manifest what they want to say, even the endorsers themselves. Let them speak. Surely we will finish this. But since this is a political process, let's allow them to say what they have to say and vote on it later on. That's all, Madam Chair.
We extended liberality to all the members in the same way that we are extending liberality to the Honorable De Lima. I think that's fair enough.
Thank you, Madam Chair. I don't think I'm in any way violating that rule because I'm not interrupting
You're not,
anybody
ma'am.
here.
You're not violating any rule. I'm just
Yes.
saying that let the members speak and let them say what they have to
Thank
say.
you. Thank you for that.
The manifestation of SDML Defensor is duly noted as well.
So ang sinasabi ko na naman po dito, naniniwala ako na meron talagang mga allegation, factual allegations that would constitute the ground for impeachable or would constitute impeachable offense. Nasabi ko nga po kanina, per the rules, doon lang tayo dapat nakatuon. Yung mga defenses, let the respondent himself raise those defenses in the proper time. That is sa answer o kaya sa rejoinder, kung gusto pa rin mag-rejoinder, kung merong reply ang complainant. So, yung iba po kasi mga naririnig ko sa mga sinasabi for the previous speakers, defenses na po sila. Why can't we not focus our attention to the specific allegations? Later, at the end of the, pag natapos na po natin yung third ground, I can point out to those specific allegations. Ayaw ko lang po kasi mag-touch of the entirety of the complaint. But at this point, I want to say na yung factual allegations para sa akin, dun sa tatlong complaints, ay sapat. So, tungkol naman po dito sa second ground, may I now again present my analysis. Ang sabi po, PBBM abused release of 213.8 billion of unprogrammed appropriations. Factual allegations. Although, sinimulan muna po ng parang isang treatise on the legal nature of UA or unprogrammed appropriations. So may discussion muna tungkol sa kung ano at saka kung ano ang mga limitasyon ng UA. Of course, these are not allegations of specific facts, pero hindi ibig sabihin wala ng factual allegations under this ground. It may look like to be a legal memorandum, yung pagkakadiscuss sa second ground, pero sa tingin ko po, there are sufficient factual allegations that appear to establish a nexus with the ground for impeachment. Corruption, which is betrayal of public trust. Remember, isang general ground lang po ang rini-raise dito sa impeachment complaint. The second, the Maza et al. Complaint. And that is betrayal of public trust manifested in three specific grounds. 3 grounds. Pero, betrayal of public trust kasi is all-encompassing. Pwede nating sabihin na lahat ng iba na mga grounds, whether it's culpable violation of the Constitution, treason, bribery, graft, and corruption, ay kung tutuusin po, kung titingnan natin, these are all constitutive of betrayal of public trust. Kaya nga po, naiintindihan ko kung bakit yung complaint ay only alleges one general ground. So again, ano pa po yung mga factual allegations? SC declared unconstitutional the transfer of 89.9 billion PhilHealth funds as grave abuse of discretion. That is a sufficient allegation. Another, Secretary Recto admitted identification of PhilHealth fund use for UA. Sufficient allegation. Another allegation, diversion of PhilHealth funds to UA used for flood control projects was the mechanism for kickbacks. Constitutes a raid of the nation's health fund by PBBM. Ito po, this is a conclusion. Another allegation, top UA-funded contractors are now under criminal investigation. Sufficient allegation. Nakasama sa discussion doon sa causal link to corruption, which was laid down on the text of the impeachment complaint. Another, PBBM authorized release of 213.8 billion of UA for infra. 111 billion was for FCP selected in accordance with leadership priority under parametric formula. Sufficient allegation po ito. The selection criteria used, though, included the parametric formula, which is a conclusion actually instead of a factual allegation. Katulad din po yung sinabi ko with respect to ground number 1. There may be statements of conclusions or conclusions of facts, but it does not change the fact, the evident fact, that there are factual allegations na merong nag-establish ng nexus. Another, amount of UA quadrupled from amount of unprogrammed appropriations quadrupled from 250 billion in 2022 to 807 billion in 2023. Sufficient allegation. Another one, PBBM signed off on 9 SARA worth 213.8 billion, sufficient allegation. Next, PBBM used unprogrammed appropriation to circumvent congressional oversight. This is, of course, a conclusion. Parang legal treatise na naman po yung discussion dito on UA as insertions. Next, PBBM approves special budget for UA projects. Sufficient allegation. PBBM authorized 100 billion in FCPs for political patronage. This is a conclusion. So overall, a liberal treatment of this ground would favor a finding of sufficiency in substance, despite the plethora of conclusive allegations as opposed to factual allegations. Having these conclusions do not destroy the fact that there are indeed factual allegations, which when hypothetically admitted can establish a nexus to any ground, especially betrayal of public trust. Again, hindi pa po mga defenses of the possible defenses of respondent ang pinag-uusapan natin dito, kundi purely on the sufficiency of the allegations. Thank you.
Madam Chair.
We allow the manifestations of all the members of the committee, including all possible arguments. That is to guide all of us or the members as we vote this afternoon on the sufficiency in substance of both the De Jesus complaint and the Masa et al. Complaint, notwithstanding the significance of the observation of the other member on the manifestation. In our proceedings, we are actually encouraging them to give a better understanding of what we need to determine as we end the deliberation this afternoon.
Madam Chair. Madam Chair.
Is this in connection with the manifestation of the Honorable Dilemma? Because
Yeah.
we have a list, Honorable Adjong,
Yeah, just a very short manifestation.
in relation to her manifestation.
Yes, just a comment.
The Honorable Adjong is recognized.
Just a brief manifestation, Madam Chair. Madam Chair, I do completely understand and the observation and perhaps what the Honorable Congresswoman Laila de Lima would like to recommend for this committee to approach this current deliberation and current discussion that we're having right now. In particular, the assessment on how we value the sufficiency of substance of the allegations presented before us today. I do respect her views. In fact, Madam Chair, I do not even want to argue, perhaps, on the merits of what Congresswoman Laila de Lima laid out before this committee. She is known to be a legal luminary. We do value all her points. In fact, Madam Chair, the committee has been very liberal in trying to allow the former Secretary of Justice, former Senator, and our colleague to emphasize clearly what should have been the legal framework on how we approach the issue at hand, which is to assess, again, the sufficiency of substance of this matter. But then again, I would like to just point out, Madam Chair, that most of us here came out with our own manifestation and our position and observation, not necessarily to defend the respondent, Madam Chair. Because I believe that in this case, in particular, the President has all the legal resources. Should this proceed to another level, is more capable of defending himself. The individual observation and manifestation, Madam Chair, of many of our colleagues here are not defending per se the President, but this is also guided by the rulings of the Supreme Court, guided by the premise by which the Constitution laid out on how we approach impeachment proceedings. Number one, in my humble opinion, Madam Chair, first basic requirement that I would like to look into the allegation is if such an allegation established that there is bad faith in even trying to say that there is indeed an offense committed, which